Welcome back to our channel. Today's topic is one of the most debated constitutional questions: fundamental rights versus directive principles of state policy, which one prevails? This question has shaped the evolution of our constitution through landmark Supreme Court judgments. Let's start with the basics. Fundamental rights, Part 3, Articles 12 to 35. These are the civil and political rights guaranteed to every citizen. They protect individuals from arbitrary state action. Examples: right to equality, Art 14 to 18, right to freedom, Art 19 to 22, right to constitutional remedies, Art 32. Directive principles of state policy, Part 4, Articles 36 to 51. These are guidelines for governance. They aim to promote social and economic justice and establish a welfare state. Examples: equal pay for equal work, Art 39d, free legal aid, Art 39a, protection of environment, Art 48a. In short, fundamental rights. Individual-centered DPSBs, society-centered. The problem arises when laws made to implement DPSBs restrict or infringe upon fundamental rights. For example, a law that imposes restrictions on private property to distribute land more equally helps achieve DPSB's Article 39b, 39c, but may violate right to property, earlier Article 19(1)(f), now a legal right. So, which one should prevail, individual liberty or social welfare? That's where the Supreme Court stepped in through a series of judgments. Landmark case laws, the constitutional tug-of-war 1. Champakamdor-Erajan case, 1951. The first major conflict. The Madras government reserved seats in educational institutions based on caste, to fulfill DPSBs of promoting social justice. It was struck down as violating Article 15(1), right to equality. The Supreme Court said, fundamental rights are superior to DPSBs. This led to the first constitutional amendment, 1951, added Article 15(4) allowing reservations. 2. Golanath v. State of Punjab, 1967. The court said Parliament cannot amend fundamental rights. Again, FRs were held supreme. Parliament reacted strongly. 3. Savananda Bharati case, 1973. The historic turning point. Court introduced the basic structure doctrine. It said, Parliament can amend fundamental rights, but cannot destroy the basic structure of the Constitution. FRs and DPSBs were to be harmoniously balanced. 4. Minerva Mills v. Union of India, 1980. This case gave the final word on the conflict. The court struck down parts of the 42nd Amendment which gave unlimited power to Parliament to implement DPSBs. It declared, harmony and balance between fundamental rights and DPSBs is part of the basic structure. Neither Part 3 nor Part 4 is superior, both are complementary. Today, the position is clear: fundamental rights and DPSBs are not rivals, but complementary. The state must strike a balance, neither ignoring rights in the name of welfare, nor blocking welfare due to individual rights. Example: right to education, Article 21a, once a DPSB, now a fundamental right. Environmental protection, Article 48a, has been linked with Article 21, right to life. This shows the integration of Part 3 and Part 4 over time. So, to answer the big question, which one prevails? Neither, both are equally important. The Supreme Court's final word is harmony and balance between the two is part of the basic structure of the Constitution. That's the beauty of the Indian Constitution: it protects the individual, and at the same time, strives for the collective good. If you found this video helpful, don't forget to like, share, and subscribe for more crisp UPSC-focused content.